on crime. This just in for Young Thug racketeering case. We have got a decision by a judge outside of that of Judge Glanville that he is now recused. I have literally just gone over the motion now, and I'm going to go over it with you myself bit by bit. Starting first with the finding of facts. We all know what the facts were. There was an ex parte, meaning one of the parties, that being all of the defense attorneys, were not present for this meeting with Kenneth Copeland. Judge Glanville, along with the prosecution and Kenneth Copeland's attorney, had this in-chambers meeting talking about him pleading the fifth for about four pages. So about four or so pages, just the facts as we remember them. This meeting happened. Glanville went back and forth deciding, is this person going to testify? You cannot plead the fifth. The prosecution, as we saw the transcripts that were later released, kept pressing. You've got immunity. You cannot be prosecuted for this in any way, shape, or form. And that means you have to testify. Ultimately, that meeting was not expressed in detail to the defense until Brian Steele, the defense attorney for Young Thug, raised this issue. Following that, multiple defense attorneys filed motions for recusal. Now, moving on from the facts, going to the law, the legal framework for what a recusal requires. There are three criterias that needs to happen. Those being, the motion needs to be timely, needs to be supported by an affidavit, and the facts alleged need to show that a recusal might be warranted. Now, to the first two parts, Judge Glanville himself said that this is timely. When the defense found an issue, they brought it up. The second part, he said that there's an affidavit that was filed. Good. But the reason why Judge Glanville himself said that he's denying the recusal is because he argued that the facts alleged did not warrant a recusal, that they did not meet that threshold. However, he ultimately passed this case on to another judge, and this is the judge's analysis and discussion. It's just a quick, I wouldn't even call it 2 pages. I'd call it a page and a half, if that. And the judge does start off by saying, as previously announced on the record, this motion was timely and supported by an affidavit. Already got that. But moving on to the next part, the court kind of pauses and says, you know what, it's worth noting, and I'm just quoting here, that this court agrees generally with Judge Glanville's assessment of the proprietary of the meeting, that ex parte meeting, saying, okay, that's okay to happen. While the meeting could have and perhaps should have taken place in open court, kind of giving that option there, nothing about the fact of this meeting or substance discussed was inherently improper. However, and this is the big however, in his order denying defendant Kendrick's motion and in the process of making a record on July 1st, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Just going to keep going through here. While, and I'm quoting here, may be appropriate for judges to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. As we saw in Judge Glanville's recitation of why he was not recusing himself, he was, let's just say he was definitely a little hostile. In presenting this record as to the recusal issues and in ruling on Kendrick's motions, Judge Glanville, quote, evaluated and accepted the truth of his own fact.
Took us a while to find this winner. I'm looking for Sonia.
No way.
Is that you?
Actual allegations mandating his recusal. What that basically means in English, he played both witness, judge, and jury in deciding the veracity and the truthfulness of his own allegations. A judge cannot do that. That's what the Honorable Judge Rachel Krause, who was given this case to decide the recusal, ultimately decides. They continue by saying that this court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but, and going on to quote here, the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. And this is the decision. Based on the foregoing, this court hereby orders the following. 1, Defendant DeMonte Kendrick's motion for recusal of the Chief Judge Yearville is granted. 2, Caleb Bumpus' motion to quash the show cause order or for the recusal of Judge Glanville is denied as moot, meaning that it's no longer an issue, and that the defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville for all further dealings in the above referenced case as amended and supplemented is granted. The court clerk shall reassign this case using the court's case assignment procedures. This is the order of the judge as of the 15th of July for the year of 2024. That is today. What that basically means is Judge Glanville is no longer the judge in the Young Thug Rico case for any of the defendants. It will go back to the court clerks to reassign this case. This is the breaking news coming out of the Young Thug case in Georgia.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never—
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason—
Well, I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's
Well,
a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of the record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going
did
to
you-
answer that question.
You're not.
No, I will not answer that
Why
question.
will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to
No.
get anybody else
I'm
into
asking you,
any-
how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now. and
Okay,
I'd like to
I know.
consider-
Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
A party,
yes.
a witness who was sworn in Friday. The court's telling. This is what I was told. If this is not true, not true. This court
Mr. Steele,
handed
ask
Mr.
me.
Copeland.
Tell me how you
perjury.
got. Tell me how you got the information.
Listen. Whatever you want to do.
Tell me how you got the information. Then we can
I'm-
go ahead and go forward.
I'm not going to say that. What I'm going
Well-
to say is this. I was told, and I hope this concerns the court.
It
I was
concerns me that you have proprietary information
Why is it
or
proprietary?
information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how
do.
did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who
I'm not, I
tell me who this information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
You don't
who
have to. I'm
if
going
you don't tell me who it is, I'm going to put you.
Well, let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you?
telling
How did you get that information
I don't
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes.
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Imagine hosting a charity 5K without high-quality custom t-shirts.